Good morning, good afternoon, and good evening. Welcome to Course 14 of the Monique and Roland Weil People's Academy of International Law. My name is Marjorie Cohn, Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers, IADL. Today, we will discuss the role of women in the struggle for peace and feminist justice. This program is dedicated to our beloved Evelyn Dermeyer, who recently passed away. Evelyn was a champion of human rights. She worked for the human rights of women and girls subjected to the atrocity crime of non-state torture. She was editor of the International Review of Contemporary Law and represented IADL at the UN Commission on the Status of Women. Evelyn was the daughter of two Holocaust survivors. Her father introduced Evelyn to IADL. Evelyn touched countless lives during her abiding work and commitment to peace, freedom, liberty, and social justice, always with compassion and grace. We will not see the likes of her again. Achieving women's freedom is intertwined with resisting war, militarism, and imperialism. The forms of women's oppression result from patriarchal structures, as well as unilateral coercive measures or sanctions, constituting economic warfare, military intervention and domination, occupation, and authoritarianism. The struggle for women's rights is a struggle for the human rights of all. Gender apartheid includes violations of individual rights, as well as the systemic segregation and exclusion of a group that constitutes half of society from public life. Historically, apartheid described racial segregation, yet the regime imposed on women in Afghanistan is increasingly understood as a gendered form of apartheid. Grave human rights violations, war crimes, crimes against humanity, and genocide affecting women are being committed in many states. More than 38,000 women and girls have been killed in Gaza between 2023 and December 2025. That is an average of at least 47 women and girls killed per day. Israeli forces systematically employ rape and sexual torture to humiliate Palestinian female detainees, a recent report by Euromed concluded. Palestinian women have been central to the struggle for peace and justice. They are an important example of an indigenous people affected by colonialism, conflict, occupation, war, and genocide, who have, as a result of the Israeli occupation, lost jobs, been prevented from attending schools and universities, been wounded, deprived of health care and housing, experienced the killing of their family and community members, been imprisoned and tortured. On February 28th, the day the US and Israel launched their war of aggression against Iran, US forces killed 180 students and teachers at a girls' elementary school in Minab in southern Iran. Intentionally targeting civilians is a war crime under the Fourth Geneva Convention. Monique Picard-Weil was a lawyer and an activist for whom, along with her husband, Roland, the People's Academy is named. Monique called the ban on abortion a singular form of repression against women. She said the control of procreation and birth was part of the struggle for human liberation. Monique thought the relations of male-female domination should not replace the class struggle, but rather be integrated into it. Today, we will address strategies for eliminating violence, for ensuring and strengthening gender equality and access to justice, by promoting inclusive and equitable legal systems, eliminating discriminatory laws, policies, and practices, addressing structural barriers, and increasing full and effective participation and decision-making in the public life of all women and girls. Our distinguished faculty for this course includes Rashida Manjoo, Dinora Laluz, Elena B. Mendoza, Dr. Gisela Jimenez Aranguren, and Sharon Usal. Each of them will speak for 20 minutes, followed by a discussion between the faculty members and then Q&A with all of you. We have Spanish, French, and English translation. You can select your language at the bottom of your screen. Please put your questions in the Q&A box for our discussion. We will soon post on our website, peoplesacademy.net, the faculty presentations in English, Spanish, and French, along with links to relevant articles. You will receive an email when the program is posted. Our first faculty member is Rashida Manjoo. Rashida Manjoo is Professor Emerita at the University of Cape Town, South Africa, where she taught for many years in the Faculty of Law and convened the LLM Human Rights Program. She continues to supervise PhD candidates on the faculty. She has over 5 decades of experience in social justice and human rights work, both in South Africa and abroad. Between 2009 and 2015, she held the position of United Nations Special Rapporteur on Violence Against Women, Its Causes and Consequences. Her UN work over 6 years has included monitoring and reporting on states' compliance in responding to and preventing violence against women, its causes and consequences, both generally and in different country contexts. Professor Manjoo is the former parliamentary commissioner of the Commission on Gender Equality, an institution created by the Constitution of South Africa with a mandate to oversee the promotion and protection of gender equality and women's rights. She has also been involved in social context training for judges and lawyers, where she has designed both content and methodology. Professor Manjoo will discuss violence against women, normativity with substantive legality. Professor Manjoo.
Thank you. Thank you, Marjorie, and thank you very much to the People's Academy. I have a very unstable internet connection, which has been worsened due to storms in my province. So I will switch the camera off in a little bit, but I first want to acknowledge Marjorie setting the scene in terms of the broad range of issues that will be addressed, but more importantly, that this particular session the goal is to honor a comrade, Evelyn Dermeyer, who was an exceptional lawyer, advocate, and activist in the struggle for peace and feminist justice. Importantly, Evelyn was a human being in the true sense of the word in terms of inclusiveness, gentleness, but speaking truth to power in every forum that she occupied. She worked on many substantive issues, from non-state torture to violence against women and the normative gap in international law, to other issues. And many of you have worked with her in IADL. So I think it's testimony to the People's Academy to honor and pay tribute to someone who we all loved, worked with, and hope to emulate in all the spaces that we work. So thank you very much to the People's Academy and to Marjorie in particular. I will switch off my camera now. I had shared an article which you probably have received on closing the protection gap in international law, and I will be addressing aspects of that article. So, as an introduction, the role of women in the struggle for peace and feminist justice is clearly visible in the many spheres of international law, policy, and practice, including on the issue of violence against women. The need for binding international law is a core imperative for many feminist human rights advocates and activists in the quest for justice and accountability. For decades, women have been working within the understanding that international laws matter and that reinforcing the specificity of fundamental rights in law is crucial, including the right to equality, dignity, non-discrimination, and a life free of all forms of violence, both public and private. It is acknowledged that treaties establish both norms and binding legal obligations, which reflect a commitment to a set of explicit legal obligations in protection and prevention efforts, as well as international accountability. Treaties provide a political, legal, and social resource to individuals and groups who work towards holding governments accountable. They impose political costs for non-compliance and can have the power to constrain. I said can have the power to constrain. They don't always do. Treaties set visible goals and can serve an educative function, leading to domestic legal, institutional, and jurisprudential developments in efforts to advance justice and accountability goals. In the sphere of violence against women, the role of women in the struggle for peace and feminist justice is reflected in the decades of advocacy and activism. Violence against women is currently acknowledged as a pervasive and widespread human rights violation, whether occurring in private or public spaces, and whether perpetrated by state or non-state actors. It occurs in times of peace, conflict, disasters, epidemics, transitions, and post-conflict times, and in homes, in communities, in state institutions, and other places. Women and girls are disproportionately affected and impacted by gendered violence, which targets them based on both sex and gender grounds, that is, biological and social constructs of womanhood. The issue has been described as a global health pandemic by the World Health Organization, as a shadow pandemic by UN Women during COVID, and has been interpreted as a prohibited form of discrimination by the Committee on the Elimination of All Forms of Discrimination Against Women, CEDAW. Some of the continuing challenges regarding the prevention, protection, and elimination of violence against women include, amongst others, the persistence of patriarchal social and cultural norms, the gaps in laws, policies, and practices, the poor global progress on gender equality, the global pushbacks on women's rights and gender equality, the growing problem of armed conflicts, as Marjorie alluded to earlier, the democratic backsliding which is resulting in authoritarian and repressive governance in many countries, the privileging and encouraging of soft law developments to avoid any legally enforceable accountability, and the lack of attention to addressing justice and accountability issues, thereby promoting and supporting impunity. In terms of standard setting and normative framings, the evolving acceptance that violence against women is a specific human rights violation linked to civil, political, economic, social, cultural, and developmental rights is evident in the work of the UN agencies and experts. This is, however, manifested through soft law normative framings within the United Nations system. Decades of feminist civil society advocacy on violence against women has included activism at the UN World Conferences in Mexico, in Copenhagen, in Nairobi, and finally in Beijing in 1995. The first General Assembly resolution on domestic violence, limited just to domestic violence, I stress, domestic violence in the family, was adopted in 1985. That's not that long ago. In 1991, a UN expert group meeting was held in Vienna based on a call by the UN Commission on the Status of Women for an international instrument that would explicitly address violence against women. Unfortunately, caution prevailed at this meeting, and the meeting recommended a declaration on the elimination of violence against women and produced a draft declaration, as opposed to a legally binding instrument. At the 1993 World Conference on Human Rights held in Vienna, there was very strong advocacy by women again for the recognition of women's rights as human rights and violence against women as a human rights violation in and of itself. The advocacy also resulted in pushing for the adoption of the declaration developed in 1991 at the Vienna meeting. This was adopted in 1993 as the Declaration on the Elimination of Violence Against Women, again a soft law instrument. The promotion of soft law normative framings in respect of violence against women has been the practice of the committee monitoring the UN Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, which was adopted in 1979. This anti-discrimination treaty does not include a comprehensive and holistic provision on violence against women. Article 6 of CEDAW is limited to the suppression of all forms of traffic in women and the exploitation of prostitution of women. Using its interpretive discretion in terms of the Vienna Law and Treaties, the CEDAW Committee has defined violence as discrimination in terms of Article 1 and linked it to the obligation to eliminate discrimination by state parties in terms of Article 2. The committee has done this through numerous general recommendations which have been adopted over the years to provide guidance to state parties on the interpretation of the treaty. The committee has adopted general recommendations number 12, 19, 30, and 35, specifically on violence against women.
Wouldn't be home tonight, so we'll do something together tomorrow.
Oops. Okay. The CEDAW Optional Protocol, adopted in 1991, addresses a legal gap in the original treaty through codification of an individual communication procedure and also an inquiry procedure. This legally binding normative development is the only one to date in respect of CEDAW and its discrimination mandate. Despite numerous violence against women cases being filed with the committee, there has not been the development of binding legal provisions within the UN on the issue of the legal gap in international law regarding violence against women. In addition, there have been other historical and current developments regarding UN soft law standard setting in respect of violence against women. These include the 1993 Declaration on the Elimination of Violence Against Women, as I mentioned, the 1994 creation of the mandate of the UN Special Rapporteur on Violence Against Women, its causes and consequences, numerous resolutions by the General Assembly, the Commission on Human Rights, which is now the Human Rights Council, and the Security Council resolutions on women, peace, and security, Again, all non-binding resolutions. At the regional level, specific instruments on violence against women, which create legally binding obligations on states, include the Bellum de Para in the Inter-American Human Rights System, the Istanbul Treaty, which is adopted by the Council of Europe, and the Convention on Violence Against Women and Girls, which was recently adopted by the African Union, but it is not in effect as yet. There have been 7 signatures, but no ratifications to date. So what are the current developments to address the legal normative gap in international law? Addressing the issue of a normative gap in international law on the issue of violence against women has been undertaken in recent years by the UN Special Rapporteurs on Violence Against Women and feminist women activists working in civil society organizations. In a 1996 report, the first Special Rapporteur on Violence Against Women noted that the international community should consider the possibility of adopting an international convention on the elimination of violence against women. The second Special Rapporteur did not address the issue raised by her predecessor. Between 2009 and 2025, there have been numerous efforts by the third, fourth, and fifth, the current Special Rapporteurs, on the need for an international instrument addressing the legal normative gap on violence against women, including in reports to the Human Rights Council and the General Assembly, support by a core group of states, including Antigua and Barbuda, Costa Rica, the Democratic Republic of Congo, and Sierra Leone, and importantly, advocacy work by civil society, individuals, and organizations. The current proposal that has been agreed upon by the 3 special rapporteurs is that there is a need for a new CEDAW optional protocol to comprehensively and holistically address violence against women and girls, explicitly as a human rights violation with clearly articulated state obligations. The current Special Rapporteur, during her 2025 reporting to the Commission on the Status of Women, reinforced the need for an international instrument to address the normative protection gap. She emphasized that and I quote, that the adoption of an optional protocol will not only reaffirm our commitment to sex and gender equality, but also provide a concrete legal tool to hold states accountable. Based on a position paper that she was working on, she highlighted 4 elements that should be included in a new optional protocol. These include the articulation of legal definitions and forms of violence. Secondly, state obligations to end, prevent, and respond to violence against women. Thirdly, clear ways in which the protocol complements existing instruments and standards. And lastly, to specify implementation and monitoring mechanisms that are needed for effective implementation of this new optional protocol to CEDAW. There has been pushback from the CEDAW committee, some UN agencies, and also some civil society individuals and organizations. The CEDAW committee has been negative in its response to discussions about the normative gap and has insisted that the principle of non-discrimination in the Convention covers gender-based violence against women and girls. In General Recommendation 35, the committee also asserts that the prohibition on violence against women has reached the status of customary international law, and there's a question mark here as well. In 2025, the committee released a public statement, and this was, in response to the call by the 3 special rapporteurs for a CEDAW optional protocol. The statement asserted that, and I quote, "The committee is convinced that a new optional protocol might create a parallel process that would undermine full accountability under the Convention. There is no additional information, explanation, on how this conclusion is reached by the committee, considering the lack of discussions, open discussions about a possibility of a new CEDAW optional protocol. So closing the protection gap, and the article that has been prescribed for your reading for this session has included, the article has been included. It provides an overview and analysis of comparative models of treaty-making processes and proposes a way forward regarding the procedural aspects for a new CEDAW optional protocol on violence against women. So it doesn't address the substantive aspects of what should be in an optional protocol, a CEDAW protocol, because that would be disrespectful. The substance should be a broader discussion by feminists, activists, academics, UN bodies, etc., and experts within the UN system, as well as people from within the three regional human rights systems that have a specific binding treaty on violence against women. So this paper just looks at what is the procedure in terms of other optional protocols that have been adopted. And the article analyzes the political and advocacy process of development of one treaty and 4 optional protocols. The objective of the paper was to identify the normative and protection gaps that needed to be addressed and to identify approaches, key factors, dynamics, participants, responses, timelines, and challenges in the development of an optional protocol. The Convention on the Rights of Persons with Disabilities formed part of the analysis as it was adopted in 2006, and it is the latest comprehensive standalone treaty adopted to fill a protection gap due to the legal lacuna in the international human rights sphere. Of the 9 optional protocols analyzed, 5 are related to procedural aspects, that is linked to individual communication procedures and some with an inquiry procedure. 4 optional protocols that were analyzed are related to substantive topics that were not fully addressed in the original treaties. One on the internet, the 4 include 2 linked to the Children's Rights Convention, 1 to the International Covenant on Civil and Political Rights, and 1 linked to the Convention Against Torture. The last optional protocol is different from the other 3 as it addresses both substance and procedure aspects. The analysis of the case studies highlighted 5 commonalities. There are differences in how each of these optional protocols were managed, but they also highlighted 5 commonalities in the procedure process, including state leadership, NGO engagement, the role of designated committees or working groups at the UN level, high-level UN agency support on the particular issue, and acknowledging that there will be dissents, disagreements, and lack of consensus in the development process. Thus, there will be a need for compromise and consensus building during the negotiations on optional protocols. The article then highlights how the elaboration and negotiation procedures process in respect of a CEDAW optional protocol could proceed. This would most often start with the adoption of a resolution through the Human Rights Council, which meets the first criteria of state leadership. So you require states to take leadership and table a resolution through the Human Rights Council and/or the General Assembly. Considering that violence against women and girls is a human rights issue, the article notes that the starting point should ideally be a resolution through the Human Rights Council. NGO engagement was a second factor that was identified in the article by my co-author and myself. And NGO engagement, as wide as possible, is really important, not only not only relating to the NGO meetings, etc., but also being part of the negotiation processes as NGOs participating during state negotiations. The role of designated committees or working groups at the UN level is a development that occurs after a resolution is adopted, discussions are held on the protection gap, and then working groups are designated, and working groups are usually members of member states. Sometimes experts are included, but more often it is restricted to member states. The fourth element is high-level UN agency support on the particular issue, and we see this in the issue of the disability sector, where UN DESA had a huge focus on disability, and research papers, conferences, the participation of academics, NGOs, feminists, etc., was a very clear. And so when the disability treaty was being negotiated, there was this huge amount of work that had already been done by DESA through its project on disability, and that could help to feed into and assist member states who are sitting in working groups. And acknowledging dissent, etc. We've seen this as part of negotiation processes, and that there's always going to be compromise, consensus building, etc. So in closing, there is a need for the role of women in the struggle for peace and feminist justice to be revived. I think we are at a standstill in the struggle to close the normative protection gap in respect of violence against women. And I encourage us to think about what is it that holds us back, because there is a huge amount of discussion going on about codifying gender apartheid in the Crimes Against Humanity Treaty, on sexual violence in conflict, and yet all we get is non-binding resolutions on women, peace, and security in the Security Council. But this larger discussion on a holistic approach on the need to close the protection gap on violence against women is not a discussion that's in the public domain in the way it should be when we think about feminist advocacy over the years. Thank you very much for your attention.
Thank you so much, Professor Manju, for explaining the parameters and consequences of violence against women, as well as the challenges to accountability. And thanks for presenting the history and shortcomings of the UN instruments and the adoption and proposing the adoption of new instruments and NGO actions to overcome impunity for the normative protection gap and violence against women. So thank you so much for that. Our next faculty member is Dinora Laluz. Dinora Laluz completed a PhD in history and a Master of Laws, an LLM, in comparative law, with a certificate in international public law from the Henry Dunant Institute in Geneva and René Cassin Institute in Strasbourg. Dr. Laluz has been active as a legal consultant, editor, and board member in non-governmental organizations with advisory status at the United Nations in New York and Geneva. She has published articles locally and internationally about international human rights, public international law, women's rights, international relations, and history. She will discuss human trafficking, a form of slavery, and violence against women. Dr. Laluz, the floor is yours.
Thank you, Marjorie, and thank you all our partners in the panel. It's an honor to be here, and it's also an honor to be sharing with you. After hearing the bad news that Evelyn is with us anymore. So yeah, we some in the Latin American region and the Caribbean, and slavery, human trafficking, and all of this would not have any sense if we wouldn't consider all of the countries of origins or the countries that receive and organized crimes, especially human trafficking, drugs, and all of it. They all have the same road because there are many countries that participate in that same area and from different continents. So we have to walk through all the international treaties and regional treaties since the 16th century today. The 20th century, human trafficking and women trafficking started slavery and started with slavery, armed conflicts and women's visions and war situations in the Caribbean and Latin America during the colonies. And during those times, African women and indigenous women were used as slaves for as reproduction objects and as slaves and sexual objects. So what you see is a summary of the Puerto Rico, and the reality is in it's actually at the end of the presentation, but nowadays internationally there are 4 different talkers, writers about the area. There are one special and more about women against women, children, and there are relationships in regards to slavery and there are different committees and the Children Convention for Young People's Rights, where it's addressed to eliminate all kinds of discrimination and violence against women and migrants, workers, and the Committee on the Treaty about Torture. There also exists, and there are also offices against torture with the Convention Against Crime and Organized Crime. There's international organized crime, and there are committees against forced work in 2025 in the inter-American system that has a protocol to prevent and sanction women trafficking, and all of these instruments complement the UN instruments against organized crime internationally. I have some concepts that I would like to address about human trafficking. This includes internationally the additional protocol to the Convention Against Organized Crime, which is known as the Protocol to Prevent and Sanction Human Trafficking, especially women and children. And we can find there a broad exemption and very specific exception of what human trafficking is in Article 3. These protocols we provide, and it's provided with psychological, legal assistance, and it's binding for the states to sanction the victims, to sanction the criminals for causing these against the victims. It was interpreted by the nations that women trafficking includes any illegal transportation of women or their commercialization for personal or economic benefit. This might include mobilizing or moving them illegally to other countries, scamming or saying lies for them for sexual purposes, and using the women physically for sexual purposes, marriage, forced marriage, prostitution, and other forms of illegal obtention of benefits. And in women trafficking, there's Brussels Treaty who try to control that situation.
En esta se disponía una oficina de esclavitud para vigilar las rutas marítimas de los tratantes de esclavos e imponía la obligación de supervisar los puertos de los países costeros. Durante el siglo XX ya, en especial después de las guerras mundiales, continuó el
Dinora,
tráfico,
please
incluso
slow
con
down.
mujeres de una
Please slow
Europa
down.
en guerra,
Thank you.
en lo que se conoció como la trata de blancas, para
Dinora,
luego
please
llamarse.
slow down. Please slow down.
Okay.
Thank you.
sorry. Tráfico de personas. En el siglo XX se penalizó la prostitución, los delitos de proxenetismo y se sancionó la trata interna o internacional. Por ello se habla de las redes europeas, asiáticas, en especial Japón, y redes de operación y reclutamiento en América. Por ejemplo, en Brasil, Surinam, Colombia y el Caribe. Por ejemplo, República Dominicana. También como centros de distribución se encuentran España, Grecia, Alemania, Bélgica, Holanda. Las mujeres provenían y provienen todavía especialmente de América Latina y del este de Europa, como por ejemplo Rusia, Lituania y Croacia. Los instrumentos internacionales en la primera parte del siglo XX disponían para los casos de trata de personas en que se transportaba a través de fronteras internacionales a mujeres y niñas sin su consentimiento. Pueden poner el mapa de las redes o del tráfico de personas en la otra diapositiva, si la tienen por ahí, sin su consentimiento, con el propósito de prostituirlas. Un ejemplo de estos fue el Convenio Internacional para la Represión de Trata de Blancas de 1910. Se crearon 3 convenios adicionales que quedaron agrupados en el Convenio para la Represión de la Trata de Personas y de la Explotación de la Prostitución Ajena de 1949. So you can show the next slide on the map on the different countries involved in human traffic. If you can, and if you have the slide, please. Okay. El grupo de trabajo sobre las formas contemporáneas de esclavitud interpretó en su recomendación de 1998 que la trata transfronteriza de mujeres y niñas con fines de explotación sexual es una de las formas contemporáneas de esclavitud y constituye una violación grave de los derechos humanos. CIDO, que protege específicamente los derechos de la mujer, en su artículo 6 obliga a los estados partes a adoptar todas las medidas, incluso en cuanto a la legislación interna, a eliminar el tráfico de mujeres y a la explotación, la prostitución, o sea, eliminar la explotación y toda violación de los derechos humanos. Otros instrumentos incluyen Declaración y Programa de Acción de Viena de 1993, la Declaración y Plataforma de Acción de Beijing de 1995, que también condenan la violencia contra la mujer y todas las formas de explotación sexual, las cuales son incompatibles con la dignidad y derechos de la mujer. La trata de niñas es especialmente preocupante debido a los métodos utilizados, los cuales incluyen la prostitución, la pornografía, las adopciones ilegales y la explotación laboral. El Convenio sobre los Derechos del Niño y de las Niñas, perdón, que se me fue. Mientras tanto, si pueden pasar por favor el otro, el mapa. Can you please show the map? The other slide, please.
Okay, bien. Gracias.
Thank you.
The example of this the convention of 1910,
fue el Convenio
there were
Internacional para
three
la Represión de la Trata de
that
Blancas
were
de 1910. Se crearon
that
3
were
convenios
dealing in
adicionales que
exploitation
quedaron
and
agrupados,
traffic
como dije,
and
en el Convenio
prostitution
para la Represión
in
de la
1949.
y la explotación de la
The working
prostitución
group
ajena
of
de
contemporary
1949. El
forms of
grupo de
slavery
trabajo sobre las
interpreted
formas
in the
contemporáneas de
recommendation of
esclavitud interpretó
1998
en su recomendación número
cross-border trafficking
198,
of women, of girls, with the purpose of
que la
sexual
trata
exploitation is
transfronteriza
one of
de
the
mujeres y niñas
contemporary
con fines de
serious
explotación
violation
sexual es una
of human
de las
trafficking,
formas
of human rights.
contemporáneas de
I'm sorry if
esclavitud,
I'm repeating.
constituye una violación grave. Perdonen que ya lo repetí.
The Hague Convention of Protection of Children and Cooperation in Respect of International Intercontradiction from 1995 deals with the issues on adoption, providing that no person shall obtain improper benefits in any activity related to an adoption from another country. In 2004, the Office of the Special Rapporteur on Trafficking in Persons, which deals specially with women and children. This mandate was renewed in 2023. The rapporteur works in conjunction with the United Nations Office on Drugs and Crime. Between 2020 and 2023, the numbers of traffic victims increased to more 25%, 200,000 victims. The mandate includes actions such as on-site visit, making recommendations, and submitting annual reports on activities related to this mandate. The rapporteur on contemporary forms of slavery, including its causes and consequences, admits that despite the goal of ending child labor, this has not been able to be achieved. It makes recommendations to governments and internationally to other companies. As a component of the Convention on the Rights for Children, there is the Inter-American Convention on International Traffic of Minors, which defines the scope of smuggling and traffic of minors and specifies that a minor means anyone under 18 years old who is trafficked internationally. The illegal causes of trafficking and both the reports by the UN Committee on Population Development, the ECLAC, the NGO, Latin American and Caribbean Committee in Defense of Human Rights, and the Inter-American Children's Institute indicate that the causes of migration and illegal trafficking are poverty, insecurity, domestic violence, and armed conflicts in their countries. It is also attributed to the factors such as patriarchy in the region. So the modalities of smuggling and trafficking of persons include sexual tourism that's sponsored or permitted by the state, both the Special Rapporteur on Trafficking in Persons and the previous Commission Human now is the Human Rights Council on February 1 of 2011 put forth principles and guidelines on human rights and trafficking in persons. The latest reports contain a summary of the negative consequences of the aftermath of colonialism on the enjoyment of human rights. This is related to colonialism. The case of Puerto Rico is an example of how the impositions that come from the United States for supposed development through tourism have caused the opposite. Luis López Rojas maintained that under the development of tourism, they promote prostitution in the island since 1960 onwards. In 1963, the Secretary of Justice announced that in Puerto Rico, there was a structure of trafficking of women who were brought from Latin America and the United States. According to Lopez, prostitution took advantage of the boost given by the government at that time, Luis Aferré, during 1969 to 1972, and to tourism to expand a way of expand this demand. Between 1969 and 1973, foreign women from Colombia, Mexico, the Dominican Republic, Panama, Argentina, Uruguay, and the United States made 80% of the prostitutes in the metropolitan area. And this was one of the most lucrative activities of organized crime. Prostitution, forced prostitution, and serious sexual abuse were included in the Rome Institutes of the International Criminal Court as crimes against humanity and as part of a widespread or systemic attack against any civilian population. International humanitarian law establishes that forced prostitution is an international crime. The International Labor includes in the Convention number 182 the worst forms of child labor and the use of children for prostitution. The previous commission, the Human Rights Council, approved in 1992 the Program of Action for the Prevention and Sale of Children, Child Prostitution, and Child Pornography, and indicates that such practice constitute contemporary forms of slavery. Child prostitution and child pornography can include or originate from the sale of minors and illegal adoption. It can be by a stranger or by family members themselves who sell them for sexual exploitation. Sexual slavery is used as the sexual slavery through the use of force or threats of use, and it differs from prostitution in that sexual slavery does not require a reward or a profit. Another way that this happens is in forced labor in the sweatshops or maquilas, where the work, where human rights have published the Guatemalan government, as well as the frontier of Mexico and the United States, San Diego, allows the multinationals maintain sweatshops in violation of labor and wage laws. This is just to mention some of the countries where corporations are violating human rights, as documented by more than 250 NGOs are part of the global campaign for a UN binding treaty. Another one is forced marriages. The sexual, physical, psychological, domestic violence, and sexual are hidden in these marriages. The Temporary Commission on Slavery in 1924 included in the list of practices analogous to slavery, like the acquisition of a girl, through disguised purchase in forms of payments of the dowry. In 1956, the Supplementary Convention indicated that abuse is constituted by force or non-consensual marriage. Another one of the prohibited conducts when a relative or a client of the husband had an alleged right to cede the wife to a third party for consideration, or that the widow, after the death of the husband, had to immediately marry a member of the deceased family. Another modality, there too, the mail order brides, is another form of sexual exploitation that is prohibited by CEDAW. And domestic worker as a form of informal work that also can include other works that are not protected. For example, in the entertainment industry, dance, pornography, film, massage, and prostitution, as I said before. Puerto Rico is a bridge and a receiving country for illegal immigration. According to Estonian Duani Hernando Silreyes, since the 1960s, mentioned that there has been
desde la década de
an increase in the
1960
undergrounds of the economy, the underground economy in Puerto Rico,
expresan que ha habido un
along with
aumento
increase
en la
of
economía
undocumented
subterránea en
immigration,
Puerto Rico
especially from
junto
Venezuela
con el
and
aumento en la inmigración indocumentada,
Dominican
especialmente
Republic to
desde
Puerto Rico.
Venezuela y República Dominicana
In
hacia
1990,
Puerto
Puerto
Rico.
Rico became
En
one
la
of the
década de
favorite avenues or
1980,
bridges
Puerto
to
Rico se
enter to the
convirtió
United
en
States
una de las
illegally.
vías favorecidas o puentes
Some
para
scholar
entrar
has said
ilegalmente a los
that the
Estados Unidos.
IRCA law, Immigration
Algunos
Reform Control Act,
académicos han sugerido que
is
la ley
stimulated
IRCA o
immigration by
Immigration
creating the
Reform and
exploitation
Control
of
Act
general amnesty for illegal
estimuló la
workers.
inmigración al
In
crear la
1990, the
expectativa
Immigration
de
and
una
Naturalization
amnistía
Service
general para los
deported
trabajadores ilegales. En 1890, el
35,390
Servicio de
foreign
Inmigración y
nationals from the United
Naturalización
States.
deportó
Today, it has increased
35.390 extranjeros de los Estados
600,000.
Unidos. Hoy día,
So
esa cifra ha aumentado a
there's a part that
600.000.
had to exclude here
Así es que hay
in
una
terms
parte que
of
tuve que
legislations
excluir
the United States and Puerto Rico because of
respecto a
time.
la
But
legislación de
as
Estados Unidos y
we have
Puerto
to say,
Rico
some of
por
the
razones de
federal
tiempo,
cases,
pero basta
since
decir
some of the
que
19
los casos
data
ante los tribunales federales,
that we
según
have
datos
been
del
published
2018, que es lo más
from the
reciente
Human Trafficking
que,
Institute,
que
it
han
reflects
publicado
13
del Human
cases of
Trafficking
human trafficking
Institute,
and the federal courts
reflejan
in
un
Puerto
aumento
Rico.
de 13 casos activos de trata humana en los tribunales de Puerto
And
Rico,
one of the
del
journalists
Distrito Federal en Puerto Rico,
that has been
y
documented these cases
una de las periodistas
talked about 11 arrests
que
in
han
2025.
documentado estos casos
Is
informó que hubo 11 arrestos en
267%
2025.
increase,
Esto
more
es
than 2018.
267%
There was only one arrest and
más
only
que
one
en
conviction.
2018.
100% of the
Un solo
new
arresto
accusations
y
are for
una sola
sex
condena.
trafficking, different from
100%
previous
de las nuevas
ones,
acusaciones
which was
fueron por trata
dealing with
sexual,
forced labor,
distinto a
especially
los
forced
anteriores en que se
domestic labor.
trataba
As you
de
can see,
trabajo forzoso
these
en especial
numbers,
doméstico. Así es que, como
they're
ven,
not
estas cifras
they're not
son tan y
enough,
tan
and
pocas
they
que
become not real. Thank
que
you,
no
Marjorie,
son
for the
reales. Así
invitation
es
and
que
for the
muchas
time.
gracias, Marjorie, por la invitación. Muchas gracias por la
Thank you
atención.
so much, Dr. Laluz, for detailing the trafficking of women and girls, prostitution, forced labor, and forced marriage, the routes it takes to the United States, the causes of these forms of slavery and violence against women, and for proposing measures to address them. Thank you again so much. Slavery and violence against women, and for proposing Our next faculty member is Elena B. Mendoza. Professor Mendoza has a law degree and a master's degree, and she is a doctoral candidate at the Faculty of Law at the University of Buenos Aires. She is chair of the teaching faculty in family law and social sciences at the University of Buenos Aires. She represents the judiciary of Buenos Aires, public prosecutor's office, and deputy tutelary office for mental health. She was a consultant to the Inter-American Development Bank, a member of the Intersectoral Commission of the National Council for Childhood, Adolescence, and Family, representing the National Women's Council, and an external consultant to the International Labor Organization. Ms. Mendoza is author of the book Working Childhood, From the Abolition to the Legitimization of Child Labor, which is an analysis of national and international legislation from a child-centered and gender perspective. She has published several articles in academic journals about family law, childhood, gender, and public policy. She is co-founder and academic vice director of Gender and Contemporary Law, an interdisciplinary journal of legal doctrine and jurisprudence with a gender perspective. Professor Mendoza will discuss the impact of capitalism on women's labor rights. Professor Mendoza, the floor is yours. The impact of capitalism on women's labor rights. Professor Mendoza, the floor is yours.
Thank you very much.
Gracias,
Thank you very
muchísimas
much for the
gracias.
invitation
Muchas gracias por
and
la
for
invitación.
not forgetting about our dear Evelyn, who sadly wanted to meet our country, and sadly, once she arrived, she passed away. Well, the topic I chose to talk about, to discuss, is the impact of capitalism in work rights and labor rights in women. This labor gap between men and women has a long journey in history that is born after the first industrial revolution, and is reinforced throughout the centuries to our days, where we are now in the digital era. Even though it's true that technology has many advantages, it also has aspects that are dangerous for several sectors, and I didn't say especially, but yeah, it can affect women severely. Why do I say it's the impact of capitalism? Because in the pre-capitalist society, family was one entire economical unit. What capitalism does, that is the industrial era, is it divided the family and caused that gap. There is a gap which is sustained throughout the centuries between men and women. Why do I say this? I'll show you a graph. The first industrial revolution, with the industrial era, the world is divided in public world and private world. Men go to the public world. They join the work market. Once they go in, they perform productive activities of goods and services that are profitable, and women are then isolated at home. Also, after this preconception and stigmatization of women, this is why then it's considered that the women has to be a good wife, a good mother, and take care of the house. Historically, women have had and still have an unaccredited identity. This means that this division of the public and private world places us, qualifies us as the weak gender and men as the strong gender. And this is considered a natural construction. But what feminists are forced to do is, we must say, this is not natural construction. This is not natural. This is a cultural construction that has had its development, that has expanded and has strengthened with the capitalist system. Why? Or because having women taking care of the house and the men, and then producing goods and services, and being women in charge of reproduction, that is, giving children or delivering children, and also taking charge of all the domestic activities that today we call the home care. That's how they have also qualified that free job is for the sake of love. So, as the construction says, it's something we do for love. It's a women's obligation. Now, why are women discriminated in the work field? That's precisely why. Because of this prejudice, because of this place where historically we have been placed by society. because we have family responsibilities. Usually, when the woman that gets into the workforce, joins a workforce, we know she has a double job. She has to work in itself and then take care of the children, then do the laundry, and then clean the house, and then the working hours themselves. So by having more responsibilities than men and also double the work, that's enough subjective cause to consider that if an employer has the possibility of hiring a woman or a man, they will hire the man because men have less responsibilities. But there are also objective causes for this prejudice. Men produces more or better because they are considered the strong gender. Hence, it's much more effective when it comes to goods and services production, and women are forced to produce other things or to reproduce herself. So, since taking care of that or being in charge of that is also under her responsibilities, it's also more expensive to hire a woman. Why? Because when labor rights talk about, when labor law talk about labor rights, we of course have this guarantee when we are pregnant to have a license, the pre and post. So it's a criteria that makes women getting a job more difficult, while the work we do, to all of what we do, is what holds the capital system, and it's what sustains and holds the men so they can keep progressing in their profession or the work they choose. That's asymmetric, and it's historically proven, as I said in the beginning, that was caused by the industrial era and the first revolution and the second industrial revolution, and it's been strengthening over centuries. And that myth and that asymmetry, where this myth is based on, that the myth of being the women more expensive for the employer, because also they have more days off for the obligations they have, and those are actually obligations that have been imposed naturally when they're actually a cultural construction. It's what men and patriarchy have built, and now of course that good and favors the capitalist system, because production can be improved because those who are in charge of producing goods and services of those goods that have an economic value are men, because women are the ones who hold and maintain the family life. So you notice when women get into the workforce or the market, since they have less possibilities to prepare themselves than men, because they join later, because the age where we can study or where we can get our master's degree or doctorate, that coincides, it usually matches the same age women can become a mother. So men are the ones who have more possibilities and more chances to get better studies, better works, and of course, as a consequence, better salary. That's men. But there's an interesting piece of information. And it's when women get into the workforce or get into the market, they usually reproduce the activity and the profit and the domestic activities. Women are nurses, teachers, secretary, cooker, and women is a domestic employee. So there are certain activities that are taught or society thinks and are convinced that correspond to the to women. So this division, this work division in the private and public world have turned or strengthened this difference between men and women. In short, or the bottom line is that the work market is divided by the gender perspective. It is considered that there are activities that correspond to women just for being women. And that characteristic brings disadvantages in the work environment. For instance, the salary discrimination, wages. Why? Because these gender prejudices are set and well established, those that I mentioned earlier. Women should have more days off for taking care of their house, for maintaining, for reproduction rights, just for characteristics that are natural to her, that do not belong to men. So we define this situation with a name or with a concept that is a sticky floor. Women take more to leave a home because they can only do that once their children reach a certain age. Hence, they're off time and they're older and usually with less education, and that, of course, limits her when finding or giving the quality of work she's pursuing, which means it's hard for her to get into the work environment just for being a mother, a wife, and someone who takes care of her house. Now, we named this sticky floor. That responsibility, which is something also they do for free, is what limits her to be able to grow and get into the market. But moreover, this sticky floor is combined for the same reasons, and we define it as an obstacle, as an invisible obstacle, just as sticky floor is, and this one, we call this one crystal chest, because by having these characteristics and these prejudices women have, and these stereotypes that are considered they consider belong to women, they have no possibilities to move forward in the market and the workforce. I'll use my country as an example. There are many women who work as judges, who are actually judges in different tribunals across the country. That's what we call the first tribunals. So the most that crystal chest can or would get to is to appealing. That's the civil chambers, what we call civil chambers. But it's really hard for women to get to the top tribunals in each province, which is not a third resource, but they're the ones who control the constitutionality of our laws. So the bottom line is just, yeah, they get into judicial market, but they have a crystal chest. There was just only one time in 2003 or 4 or 5 during Kirchner's government that the Supreme Court, the National Supreme Court, which is the highest tribunal, had 2 women. That was the only time the Supreme Court had 2 women. Just recently, they were talking about the Supreme Court just being with 3 male judges. So there were some comments or projects to address how we can, or they can make the exams for those who wanted to present or take the exams. And they didn't take women into account for joining the Supreme Court. So the judges, the group of female judges wrote a letter to the Supreme Court members telling them that they had violated the women's right to be part of the Supreme Court of the nation. Because also our country in 1994 reformed the national constitution. And by reforming that constitution, they introduced international treaties, human rights treaties that the state of Argentina had signed. So international treaties then started being supreme law for the nation. They cannot be just skipped or ignored. So if we consider that our national constitution is including those national treaties and our Supreme Court does not take into account the right women have to be part of it, it's really surprising that they can actually violate their own national constitution. But that's part of the male society we are part of. And yes, we have moved forward in several aspects, or very interesting ones, because, for instance, for the first time, we got the women's ministry on gender and diversity. And there were a series of programs protecting women's rights. For instance, gender violence or domestic violence. Those are several programs that accompanied protection for women against violence. And with women, I say women and children. So with this new government that started in 2023, not only the women's ministry was closed, but also all the other programs with gender perspective. That is, the Argentina has moved back significantly as a state, or as it was in comparison to how we are today. Giving same opportunities for both genders means in the workforce to be able to have professional education. And so that's how I summarize it with sticky floor and it's a crystal roof, not crystal chest, sorry. This crystal roof means the women cannot reach the professional quality we want. But with this, we are looking to have quality education for professionals, to be able to study, to able to progress in the professions we have, and have access to work positions and same payments and fair salaries. Because just by after the society considers this difference between men and women, even having quote unquote say the same rights, generally when women and men have a similar job, the men have usually superior salaries than women. So not only we do not have the same labor conditions, we also do not know what's going to happen, because while the state law included the same rights for men, women, and children, where they didn't allow hiring children under 16 years old, now that has been changed for a new law that the government declared that is now being judicialized. So if there's really a sector within society that is really harmed by all of these that I've said, that's us, we women. So in the first place, to be able to solve this issue,
para poder solucionar esta cuestión y los temas que han
first thing that we
expresado
have
las
to do, the
compañeras.
first thing that we'll
Lo primero
get
que tenemos que
dedicated
hacer,
to
lo primero
is
que
to
tenemos que
deconstruct the
dedicar nuestro
patriarchal
trabajo
society,
es a
to
deconstruir la
deconstruct the
sociedad patriarcal.
patriarchal society. It
Ese
means to
deconstruir de la sociedad
that
patriarcal
awareness, to
significa la
take
toma de conciencia,
awareness, get awareness of
pero la
men and
toma de
women,
conciencia de
because that
varones y
cultural
mujeres.
change, in
Porque el
order to
cambio
create
cultural para poder
a society that's
construir una
egalitarian, is
sociedad
to we need awareness
igualitaria
of both
es la
sectors,
toma
both
de
for men
conciencia
and women,
de ambos
and the
sectores,
empowerment of
de los
women.
varones y de las mujeres.
That
Y el
woman needs to
empoderamiento de la
understand
mujer.
that
Que
she
la mujer
needs to understand and know
entienda,
that she has the
comprenda
same rights
que
as
tiene
men,
derechos y
and she
que
has the
tiene
right
los
above
mismos
all
derechos
to
que el
live
varón.
in a
Y que tiene
society
el
that is
derecho, sobre todo, de vivir
equit
en una
that
sociedad
a society that's
igualitaria. ¿Qué
equitative,
quiere
that
decir
is
con una, quiero
when
decir, con
societies
una sociedad
are
igualitaria?
have the
Cuando
same
las
levels
sociedades
of equality and
logran
equity,
tener
that
ciertos
democracy
niveles de
that
igualdad,
comes from that
la
country is a
democracia que se
strengthened
construye en
democracy,
ese país
which is what
es una democracia
currently
fortalecida.
we don't have it in the Argentinian
¿Qué es lo que en
Republic,
este
and it's
momento
not happening
no
in
sucede en la
many other
República
countries in
Argentina
this region,
y creo que no
where
sucede
this has
en
been
varios países de la
minimized,
región,
or we have
donde se han
reversed in some of the rights of
minimizado
women.
o se han
For example, in this
derogado
country,
realmente
we have
derechos de la
heard
mujer. Por
historically,
ejemplo, en este
for
país
the first time,
se ha llegado a decir, por ejemplo,
very low
históricamente tenemos por
birth
primera
rate,
vez
and
bajísimo
the government, the
nivel de
national
natalidad.
government,
Entonces,
why say
el gobierno
why the
nacional,
birth rate is so bad, so low?
¿cómo considera? ¿Por qué
Is
considera que hay
because it's
un nivel
sanctioned
muy
the
bajo de
abortion
natalidad?
laws,
Por haber
and
sancionado la ley de
considering the lack
aborto.
of birth has
Entonces
to
considera
deal with the
que la falta de
legal
nacimiento
abortion and safe
se debe
legal
al
abortion.
aborto legal,
So in
seguro
all
y
reality,
gratuito.
there are concepts
Entonces,
that
realmente
makes you
son
pay
conceptos
attention, because
que
they
llaman poderosamente
they have
la atención,
they have a
porque
limitation in there
además
with that ignorance that
tienen
comes from it.
una,
But the
limitan
first
ahí
people that
realmente con la
suffer from
ignorancia, ¿no es
this
cierto?
kind of governments
Pero
are
las
women,
primeras perjudicadas en este
especially
tipo
where
de gobiernos
capitalism has been
somos las
strengthened
mujeres.
and
Sobre
has
todo donde
strengthened,
el capitalismo
especially
se ha
to be
fortalecido
a
y
country
se ha fortalecido sobre todo que
where
sea un
everything that is
país
being strengthened is
donde
the
se
economic
fortalece
aspect.
todo
We
lo que es
stop being a
el ámbito financiero,
productive country
¿no? Dejamos de ser un país
to just strengthen
productivo
industry and
para
employment,
fortalecer la producción, el empleo
to
y la
become
industria
another kind of
para
country.
convertirnos
everything that
en
I'm
otro
telling you, and the
estilo de país, en otra
disadvantages
forma.
historically that women have been
Todo
living
esto que yo les digo, la
because of the
desventaja
strengthening of the
históricamente
capitalist
vivimos las
systems
mujeres por el fortalecimiento del
and its
sistema
strengthening
capitalista
has also been
se
strengthened
ha
by the technology
fortalecido con el
that
desarrollo tecnológico.
digital gap
Esa brecha,
has
la brecha
increased the
digital, la brecha digital
inequity between men and women
aumenta la
and
desigualdad
accentuate
entre
the
varones y mujeres
gender
y
stereotypes. Remember what I said at the
acentúa
beginning.
los estereotipos de género.
In the pre-capitalist
Fíjense lo que
society,
yo les dije al
family
comienzo.
was an unity. It
En la
was an
sociedad
economic unity.
precapitalista,
An
la
unit. They
familia era una
reproduce
unidad
inside the house. You
económica.
reproduce inside the
Se
home.
producía dentro del
Everyone
hogar.
were
Se
working
reproducía
within the
dentro del hogar.
family group.
Todos
Nevertheless,
trabajaban
capitalists
dentro del
produced
grupo
this gap,
familiar.
this
Sin embargo,
lagoon,
el capitalismo
and
lo que
then
hizo
put
es producir
uh,
esta
uh,
brecha
they
y
actually
además
put then a
poner
different way in which we
un
actually
corte
relate to
a
our
lo que era la
parent
relación
relationship.
parental.
Women
Entonces,
become
la
then
mujer
part
queda
of the
en el mundo
private world,
privado,
even
mundo
though the work that they're
gratuito,
doing in the
a pesar de que
domestic
el
has a
trabajo que
big
las mujeres
influence
realizan en el
in terms
ámbito
of the income of
doméstico
the country, but
tiene una
nevertheless
gran
is not taken
influencia
into
en lo que es
consideration in the
los
net
ingresos del país y
earning
sin
of the country.
embargo no se
And
tiene en
that's work that
cuenta
has been
en el
done,
Producto Bruto Interno del país.
but
No
it's
se
not
tiene.
conceptualized as
Y es
work.
trabajo. Pero
It's
no es
conceptualized as a
conceptualizado como
law
trabajo, es
act,
conceptualizado
naturally
como
adjudicated to
actos
women.
de amor, ¿sí? Naturalmente
This
adjudicados
digital
a las
world
mujeres.
that we need to live has
Este
strengthened
mundo
that gap
digital
between men and
que nos
women,
toca vivir
not
ha
only in the
fortalecido la
inside
brecha entre
of
varones
the
y
country,
mujeres. No
but
solamente
among the
hacia el
different social
interior
classes.
del
And
país,
those who suffer the
sino
most,
entre las
and the women who
diferentes
suffer the
clases
most from
sociales.
this are
Y las más
are women
perjudicadas, las mujeres más
of
perjudicadas
those vulnerable
son
sector,
las
poor
mujeres de los
women,
sectores
women in
más
rural areas,
vulnerados. Las mujeres
Afro-descendant
pobres,
women,
las mujeres
indigenous women, and
rurales,
also
las
I also want
mujeres
to include
afrodescendientes,
also
las
want to include
mujeres
migrant
indígenas
women.
y también incluyo a la mujer migrante.
And why do I say
¿Por
the
qué digo
technical
que
development in general
el
development
desarrollo
since the
tecnológico
first
en
industrial
general,
revolution
el desarrollo
until the
desde la
development
primera
of the
revolución
digital
industrial
era
hasta el
has
desarrollo de la era
substantially
digital
damaged
ha
women? I'm not
perjudicado
going to deny that
sustancialmente a las
technology
mujeres. Por supuesto, no les voy a negar
has
que
that
la tecnología
that
tiene
advantage kind of
esa cara, por
position. It's
supuesto,
very useful for many
ventajosa, muy
situations, but to
ventajosa
be
para
able to
montones de
take
situaciones.
advantage of this
Pero para
technology,
poder sacar
you have to have
provecho
the
al
appropriate
uso
conditions to be
de la
able to do that, right?
tecnología, uno
And
tiene
what
que
are those
estar en
conditions? Being
condiciones.
able to have
¿Y
the
cuáles son esas
needed
condiciones?
tools to be able to
Poder
manage and
hacerse de los
administer.
instrumentos
The
necesarios
sectors which
para
are
aprender a manejarlos.
most
Los
vulnerable
sectores más
don't have access to computers
vulnerables
or
no tienen
easy access to
acceso fácilmente a las
cell phones
computadoras o
or the
fácilmente
ability
acceso
to
a los teléfonos
pay them
celulares
or
o poder
have them or pay for the
sostenerlos, poder
Wi-Fi.
pagar lo que
And that is a
el Wi-Fi.
limitation
Es decir,
in terms of learning, for
y
example,
eso los limita en
that
poder
limits their
aprender,
education in
por
all its
ejemplo,
aspects,
los
in all its
limitan
level.
todo lo que se refiere a la
It also
educación en
limits
todos sus
their
aspectos y en todos sus niveles.
the ability to go into the
También los
job
limita
market. It limits also
en el ingreso al
in terms
mercado
of
de trabajo.
access to healthcare.
También los
And it
limita
also limits
en lo que es el acceso a la salud.
access to
También
communication
los
and
limita
to
a lo
justice.
que es el
In other
acceso a la
words,
comunicación
not
y
everybody
a la justicia.
has
Es
those
decir,
elements that are
no todo
very
el mundo
needed during
puede
this
hacerse
time,
de esos elementos que
not
son
only to communicate among
indispensables
each other,
en
but
estos
also to live
tiempos,
generally,
no solamente para comunicarnos,
have
sino
a
para vivir
hearing
en general,
through
¿no?
Zoom
Desde tener
or be
una
able to pay
audiencia a
services through a
través
platform
de la
or
plataforma
being able
Zoom,
to communicate
o
with a
pagar
third person through
servicios a
the
través de
platform.
la plataforma, o poder
The
comunicarnos con
sectors,
terceras
the
personas a
poorest
través
sectors in any society. How can they do it? How can they do to obtain everything they need to be placed in this digital world in which they're living? In that sense, women who have been left behind in the job market because capitalists always consider a second kind work as a complementary work. The important money that comes into home is the money that produced by man in the job market. So I'm going to tell you something. We can sign, all the countries can sign treaties, agreements, conventions, but that's not enough. Honestly, in order to modify society and in order to formulate how everybody is in, all the members, women, men, boys, girl, adolescent girl, it's not enough to have international treaties, conventions, and national agreements. If that is not accompanied by state policies, state policies are needed in order to protect those excluded sectors. If they're not state policy, there's not going to be a society that is equitable. There's not going to be a democratic society. And this is what the capital system is trying to avoid. It is designed for a determined sector, for one purpose, for a specific social class. We live in the era of digital knowledge, of digital work, and digital relationship. The gap that is being created between men and women was intensified during this era. And I want to tell you something. This is a topic that we need to study, that we need to research. Of all the technologies, for example, in terms of social network, as I was hearing my colleague was talking about human trafficking of women, technology has strengthened all the organizations that do human trafficking, women and children, in different ways. In the same way, children, in terms of labor and slavery, because it's easier to be in touch and to communicate, but you have to realize above all, it is what it means is that algorithm. What does it mean to be artificial intelligence for women's rights? This algorithm, which are precisely models, there are steps to follow in order to obtain a determined objective. This has strengthened many of the stereotypes already in place and strengthened violence against women. So I want to say, technology, you cannot deny, is advantageous for society in general, but is needed because of that to design laws that are effective, that protect those vulnerable sectors. And without a state being present in those places, that is not possible. That's the reason I consider we need state policies. We need a state that is present, that has as its main objective and main goal is to construct a society that's equitative. When I speak about an equalitarian society and talk about all the members of society, not determined by their sex or their gender, and that is equal for everybody. That's what I mean. Thank you.
Thank you, Professor Mendoza, for explaining the effects of capitalism on the labor and economic rights of women and how patriarchal cultural patterns contribute to the economic inequality between women and men. And thanks for noting the adoption of Argentina's treaties and the challenges to their enforcement, and for proposing legal and cultural changes to close the gender gap. Our next faculty presentation will be presented by Dr. Gisela Jimenez Araguren. She is a Venezuelan lawyer and feminist specializing in criminal law, criminology, human rights, and international humanitarian law. She is a defender of the rights of women, girls, and adolescents. A former senator of the Republic of Venezuela and former representative to the Latin American Parliament, she is a national and international speaker. She is also an independent radio producer, co-founder and executive director of the Venezuelan Association of Jurists, and a member of the advisory council of the American Association of Jurists. She has represented Venezuelan civil society before the Organization of American States and the United Nations, and she has served as an advisor to the National Assembly and the Ministry of Women on gender issues. She is also the president of the Center for Peace Training and a member of the coordinating committee of the Josefa Joaquina Sanchez Women's Movement. Dr. Jimenez will discuss reflections on peace as a human right of peoples. Dr. Jimenez will discuss reflections on peace as a human right of peoples. Dr. Jimenez.
Good afternoon to everybody. I want to start to thank for this invitation that was extended to me. I'm very grateful, Marjorie Kuhn, to allow me to be part of the space that is really important. To talk about the peace as the human right of all the country. I want to say hello to all the speakers before me and be grateful and thankful for the very interesting presentation they have given us. I'm going to talk and reflect a little bit about peace. I'm going to share a presentation with you to be to have some reflections around the topic. Excuse me a second. I'm trying to find the first part of the presentation.
Well, here we'll hear about some topics that have to do with introduction, current threats to peace, peace from a feminist point of view, feminism as human rights, and feminism as the characteristic for peace, and then we'll get to the conclusions. We think this topic is important because we'll analyze the need to see peace judicially as a human right, acknowledging its ethic and politic importance, facing the military threats that right now are thriving within the international environment. And traditionally, peace as a human right, as a universal human right, linked to women's rights, which fights for social justice and feminism. Also negotiate the current imperial actions that represent threat to the international order and the fundamental rights sovereign nations have. Also, we need to address how these military and war agreements undermine international treaties and violate basic human rights people have and the peoples. So, from a feminist point of view, we need to state that feminist justice is paramount and needed to guarantee a structural order free of violence and gender violence. Here we will address the consequence of aggressions. Of course, there is human and material losses, imperialist attacks that have caused deaths, both civils and the militaries, generating a serious social impact. These, of course, focused on what's happened on January 3 in Venezuela, and also the destruction of infrastructure, public infrastructure, houses, and elements that are paramount for a good quality of life, affecting the life of very many citizens. And also the kidnap of the constitutional president Nicolas Maduro and his wife Silvia Flores, breaking judicial and political orders that defy the state sovereignty. These conclusions and aggressions are linked to those aggressions that not only generate immediate damage, but also legal and political complications that are very significant both nationally and internationally. How international tensions and military attacks deteriorate relationships between states or among states and promote a climate of disorder. Now they break the constitutional law just by imposing the law of the strongest, just by the strongest imposing unilaterally its domination, ignoring international treaties and democratical principles that are contained within different instrumental documents. So, what's even more worrisome for humanity is that movement is moving back from civilization to the old times and ancient times where just the strongest would impose its conditions in a destructive way. Now, disobeying all the agreements that had been signed just end up breaking the order that was established in treaties that were signed before to prevent global conflicts, facing what was the World War II with more than 60 million people who died, that forced us to reflect on that and establish mechanisms and treaties so that the states would be respected among each other. Then there is a break of the international order. And I think justifying aggressions are just carried out by narratives that are manipulated through invasions that are cataloged as quote unquote necessary. And these breaks ethic values that must be respected, then an increase of human suffering is produced because those aggressions violate human rights, fundamental human rights, and in some way they feed and increase the amount of refugees and migrants with tragic global consequences that are really important for all the countries, both those who receive the countries, both the country of origin and destinations. And these are very difficult situations to address. And now we'll talk about an aspect of peace from a feminist point of view. I think participation of women here is paramount. Protagonism in this within these spaces to make decisions, because women have always been isolated from those spaces and set apart from those spaces where there are political decisions, both nationally and internationally. So we are here to guarantee that women's voices are heard, and while we work together to build a long-lasting peace, because women are not or have not been absent. It just means that our voices have not been heard, and we have not received the right to participate there. So I believe women have something that is paramount, that is we fight against man's order and man's ruling. Because across history or throughout history, women have always fought against men's control and discrimination, proving that our participation is active and needed to guarantee both social justice and peace. Women's participation in peace must be carried out, and we must start from the day-to-day activities. We women build peace in schools, work centers, community spaces, promoting values of equality and respect from the base itself of society. In the second place, we think that civil and political rights should and must have that full participation and active participation with women within their political, economic, and social areas, which is essential so that we can guarantee that peace is inclusive and there's equality and equitative. So the third element would be watching that more authority we women have when it comes to fighting for peace. Women do not just participate in the conflict as victims of it. We are also protagonists in many cases, and that constant historical participation we women have had both in human rights movements and against war give us a very main role and to be promoters of sustainable peace. What are those obstacles so we can reach the peace we are looking for? We planted a hegemonic patriarchal model. We refuse that because this is a system, a model that reinforces gender inequalities and reinforces those powers that obstacle an inclusive peace that we are trying to build. And a part of this model, hegemonic model carried out by men, there is a projection within the political power and all the political areas. There are very important issues in there because we know that men's creating the rules just feed other systems that also society has had. So that contribute and feeds slavery and capitalism and all other forms of domination. So the patriarchal system feeds the others, as Ellen has mentioned before. Then we believe that violence is multidimensional, that violence is machismo, but is imperialist, political, colonialist, and these are critical barriers that difficult stability and harmony in our society. Then I think we should focus towards other aspects because there are class, ethnic, and gender disparities, and something we should add, which are socioeconomic conditions that limit our opportunities and the opportunities to build fair societies and balanced and equal societies. Another obstacle to reach peace means of communication and justification for conflicts. I was reading a Mexican journalist, and he was talking about war and how war is identified with the name of the victim. We talk about the war of Iraq, war of Libya, Afghanistan, war of, and we never talk about the war by mentioning the one who started the war. We do not give it their name. So that's why it's also important to revise the language, the wording, and how wording is used to justify the aggression, the war, and it's just one more obstacle so we can get to the peace we're looking for. So mediatic and international justice usually mitigates aggressions by invisibilizing and making noticeable the impact in life and or rights of women, and in particular, peoples in general, by using terms that change the reality and a reality that defines a certain situation. So the word is the name of the victim, but not the aggressor. Then we think there's disrespect for collective rights, not recognizing rights and guarantees, and not acknowledging that the guarantee and right to peace just perpetuate a global conflict. That's why imposing economical blockages and bonding measures against countries and the states suffering from them, those are just power and actions that are a result of power. And it's a war that has as its own goal to undermine and harm a population and then dominate them. And when we talked about this, it's because we have been in a society that is not looking for a conflict, that does not like conflicts and gets into conflicts, but still suffers this form of wars that are out because it's within the economic blockages. And since then we have the mediatic law and all the other forms of wars that I don't know. So that's why our orientation in this talk is looking to make people see peace as the human rights for the peoples. So we have in the international regulatory frames, we can see that there are acknowledgements that have been stated by the UN, but it's just a statement. They are not bonding. They are not forced to abide or comply with what's stated. So that's why we say the General Assembly establishes normatives and guidelines that acknowledge peace as a human right and a collective right within the international environment. However, this has a characteristic, this is a statement, and we need a convention to establish peace to be a right for the people. And also promoting Pacific agreements is also within the international norms that are looking to promote human respect and agreements within the countries by solving conflicts pacifically. And this is through pacific agreements. And then the right to peace and human rights have a guideline that integrate peace as a very, very, very core part of human rights, linking it with respect and the surveillance of these law system. What's proposed and what we think it's important to leave here is that we need to rethink peace and rethink about peace, and we must find a different concept that is not what we have seen throughout history so far. That's why I talk about internal development, because mentioning peace constitutionally in many constitutions in the world, like a Venezuelan call our constitution the Bolivarian constitution. Peace is mentioned and stated as a supreme value and a goal that we must reach, even though if it's not written as positive right. Many people, they have they have taken peace as a right itself. In our case, we who have studied that deeply, we must code within internal legal system right as a peace as a right. So since many of us who are here, who are connected, many of us are lawyers and are within the judiciary system, explaining further about the coding the Roman law used to establish that first we should state that human right, the human right to peace, and then take that intentionally so that we can allow that to exist as a human right itself internationally. Then we have a very limited view to the external area, because right to peace is considered as the right itself to the state and being considered exclusively related to other states and its relations with other states instead of being internal right. That is why coding peace as a human right for the peoples, that would allow us to develop and elaborate and scale an international agreement or treaty or convention. Then there is the right human to peace, classified as a solidarity right, a third generation right, which means we should receive international cooperation so we can guarantee that right within the external and internal areas. Now, how do we characterize that right to peace? I think among the obligations we, the tribunals, should have are respect to right to peace. The headlines have the responsibility and ethical obligation to respect this right, ensuring that all the actions do not violate pacific relationships nor promote conflicts. That would be an obligation that we all who have that right should have. That is, all the peoples. Because it's a human right. And then active promotion for peace. We should wait for the headlines, for the law decision makers should contribute to our goal, which is reaching peace by promoting feminism, justice, and addressing social disparities, and then also addressing all the roots the conflicts have. Because we need collaboration among the countries and all the peoples and all the states to work along so we can overcome divisions and face global threats such as the ones the imperialism has. What other obligations these right holders should have? For instance, intervene in contexts of aggression. In situations where peace is violated, those holders have the right to intervene legally and politically to establish the order that is being harmed so they can protect the collective and community well-being. Now, among other obligations is to build social justice and feminism because we owe the promotion and defense of gender equalities, and we need to eliminate the men's dominated model, and we should eliminate disparities because this is essential to consolidate a long-lasting peace. So here, education plays a big role, which is essential and paramount, so we can build a society with different values and that is loving defender and promoter of real peace. Now, the role of the citizens. Participation, of course, it's of course a pacific movement. Citizens have the right and obligation to be to be part of the change through integrating pacific initiatives that deny and refuse to be part of that violence integration that is leading. We need to build that long-lasting peace environment, and it starts from our houses. It starts at home, where the community is born, where we can promote tolerance and equality values and mutual respect all together. Now, refuse and reject violence. These right holders can refuse and have the right to refuse to participate in those acts that promote or include military, social, or political violence, hence representing these refusal as as an essential principle for peace and to defend and protect the peace. Now, what is the role of citizens within the country? First of all, promote education in peace. The citizens must get involved within values and promotion of values that promote gender equality, democratical principles, and understanding among each other. Secondly, defending human rights. The citizen role includes visualize and resist against any causes that might cause inequalities and perpetuate the conflicts by working towards a peace that integrates social justice, human rights, respect, and collective well-being. The supreme happiness, as our leader would call us, Simon Bolivar would say. Now, conclusion. Part of the sovereignty and collective right. First, peace must be understood as a human and fundamental right for the peoples and countries, and also should be taken as a principle that sustains and maintains people's sovereignty. And this principle transcends individual frontiers, so it can become an object, a collective object that demands cooperation and coordinated work among all the states and communities internationally. Acknowledging the right to peace, el reconocimiento del derecho a la paz de los ciudadanos y ciudadanas significa ejercer un derecho a ser agentes activos en la lucha por la paz.
Integrating pacifist movements to integrate promotion of peace, or simply the right to participate in any event that does any violation against peace. I'm convinced that's the way we need to go in order to really have a signifying P that means sovereignty, auto, self-determination of the countries, dignity, respect, and love for everyone. Thank you.
Thank you so much, Dr. Jimenez, for explaining how imperialist aggression leads to grave consequences. And thanks for detailing the relationship between peace and the economic, cultural, civil, and political rights of women, and also for proposing remedies for building peace and mutual respect. Many thanks for that. And also for proposing remedies for building peace and mutual respect. Many thanks for that. Our last faculty member is Serife Sharon Usal. She is a human rights lawyer from Istanbul, based in Vienna since August of 2016. She is the Co-Secretary General of the European Association of Lawyers for Democracy and World Human Rights, ELDH, a bureau member of the International Association of Democratic Lawyers, IADL, and Penn Norway's legal advisor on Turkey. She has served on the executive board of the Progressive Lawyers Association since 2015, and she is currently writing her thesis in gender studies at the University of Vienna. In December 2016, she was awarded the Dr. George Lichtjack Prize for Freedom of Speech in Austria. Ms. Usal will discuss intersectional feminist struggles for justice and peace in Turkey. The floor is yours. Will discuss intersectional feminist struggles for justice and peace.
Thank you,
in
Marjorie,
Turkey.
for the
The floor
invitation,
is
and
yours.
thank you everyone who had a chance to follow us tonight, and especially thanks to the speakers who made their contributions before me. But before starting with my presentation, I also want to say a few words concerning our beloved colleague Evelyn Durmaier. I was working with her like many others here. I was working with her very closely. And I think this is a special thanks again to Marjorie for dedicating this course to her memory. Evelyn was an important jurist, a committed member of the International Association of Democratic Lawyers, an editor of the International Review of Contemporary Law, and someone who worked within United Nations mechanisms very hardly. But I think more than that, she belonged to a political and legal tradition that did not separate peace from justice, women's freedom from the freedom of peoples, or legal struggle from political responsibility. Her work, especially in relation to the Commission on the Status of Women at the UN, reminds us of something very basic but still very urgent. Women's freedom cannot be reduced to equal rights or representation. It's part of a much broader struggle against war, occupation, militarism, imperialism, economic violence, and impunity. So, remembering Evelyn today is not only a tribute to a comrade we have recently lost, but it is also a way of thinking about her struggle through the questions of our own time. Across the world, women live at the intersection of war, occupation, colonialism, state violence, male violence, and market violence. Women's bodies are treated in many different ways, as spoils of war, as the honor of the nation, as the property of the family, or as a space to be disciplined by the state. For this reason, when we speak about women's freedom, we inevitably speak about war and peace, occupation and resistance, law and impunity, the body and sovereignty. In this talk, I will speak about Turkey, the Kurdish freedom struggle, Cyprus, Rojava, and Palestine. And I'm very happy that before me, Dr. Gizere Jimenez Aranguren already explained the main essences of this discussion, and she used the different examples from a different region. I'm not bringing my examples together simply to offer a comparative list. I think it's important to think about Cyprus, Rojava, and Palestine together because these are places where Turkey's historical and current responsibilities, crimes, denial policies, and political pragmatism become very visible. They also show us that women's struggle for peace is not an abstract language of good intentions. It's a concrete struggle for justice against genocide, occupation, in some cases displacement, colonialism, militarism, patriarchal violence, and of course impunity. Let me say from the beginning what I mean by peace. I think it's important. I'm not speaking about a soft, pink, neutral idea of peace that stands at an equal distance from all sides of a war. I use the term feminist peace deliberately. Feminist peace is not simply saying everyone should calm down, the weapons should fall silent, or the parties should sit at the table. Of course, the silencing of weapons matters. Of course, ending armed conflict is urgent. But if occupation continues, if peoples are denied their right to self-determination, if sexual violence against women remains unpunished, I don't know, if the fate of the disappeared is not revealed, if language, identity, and memory are suppressed, if courts produce state reason rather than justice, and if genocide continues before the eyes of the world, then we cannot build a real demand for peace only around the silence of weapons. This is why I suggest that we understand feminist peace as anti-militarist, anti-imperialist, anti-colonial, anti-capitalist, anti-patriarchal, and justice-oriented. But I also want to say this in a simpler way. Feminist peace asks what war does to everyday life. And it asks how war recognizes labor, how it deepens poverty, how it destroys care, and how it puts very concrete burdens on women's lives. This is where the class dimension becomes very important. War and militarism do not target bodies alone. They also target labor and reorganize it. In war, women are exposed to sexual violence, displacement, and loss, but they also carry the burden of care work, precarious labor, forced migration, poverty, and survival. When their home is destroyed, or when a hospital is bombed, when a school is closed, or let's say when the men fighting in the field, they are imprisoned, killed, or left unemployed, the work of rebuilding life often falls on women's shoulders. So feminist peace, in my view, cannot be only about legal equality or political representation, but it must also be about labor, resources, land, housing, health care, whatever we can, count on saying now. So let me make this concrete, let me give a concrete example through Cyprus, because I was in Cyprus very recently for another conference, and perhaps this is the reason why it was one of the first examples that came to my mind while preparing for this course. The Women Walk Home, the Women Walk Home marches organized in Cyprus in 80s, late 80s, are an important historical experience. They show how militarized bodies, militarized borders, occupation and division become part of women's everyday lives. In these marches, women demanded the right to return home. Most probably you are all aware of the situation in Cyprus. There is a occupied area by Turkey, and there is a long board, checkpoint between the capital city. So whenever you walk inside the city, you just come to that checkpoint and the so-called green line that was literally drawn there by the imperialist power and the occupied forces. So in these marches, women demanded the right to return home. They opposed occupation and the division of their island. And here, home is not simply a private space for them and for all of us. Home becomes memory. Home is the land. Home is the life that people insist on against displacement. So the demand of women to return their home was also a political refusal of the normalization of a militarized geography. So the demand of women to Cyprus should not be seen only a peace movement of the past. It is also one of the places where, as I mentioned before, where Turkey's military presence, occupation policy, and regional power politics have historically been concentrated. The Cypriot Women's March tells us something very important. Women's demand for peace may begin with something very concrete, like the example here, the right to return home, but from there, it opens up a broader questioning of occupation and militarized masculinity and state sovereignty. And if we return to Turkey, one of the most important fields of women's peace struggle is, of course, the Kurdish question, and I am sure that everybody has an idea about it. Here, the women's peace movement in Turkey does not come from one single tradition. We have independent feminists, Kurdish women's movement, the Peace Mothers, the Saturday Mothers, socialist women, working class women, human rights movement, I don't know, legal activists, all come from different histories and different traditions. But when we speak about war and disappearances or enforced disappearances in custody, impunity, sexual violence, these different lines come into contact with one another. And this contact has not always been easy in my country. The relationship between the feminist movement in Turkey and the Kurdish question has included contradictions, delays, silences, and moments of confrontation time to time. That is precisely why I think intersectionality here matters a lot. And it does not simply mean saying that women are different, but it means looking at how patriarchy works together with racism, colonialism, class, state violence, and heteronormativity. And of course, as we all mentioned today, militarism and the punishment. The violence experienced by a Kurdish woman and the violence experienced by a Turkish woman may both belong to the same patriarchal order, but they do not operate in the same way. Because state violence, racialization, poverty, language, geography, and experience of war all change that form, all change the form that violence takes place. The peace mothers are very important in this regard in Turkey's history, because they are not simply women making an emotional call for peace through motherhood, but they transform their loss, mourning and care and motherhood into political resistance. While defending the right to life of their children, whom the state dehumanizes through the language of terror, they ask society a very important and hard question to answer. Which deaths are considered grievable? Which children are recognized as human? And of course, which mother's pain is allowed to be legitimate? And these questions bring us to another example, this time Saturday mothers. They remind us one of the most basic conditions of peace in Turkey. There can be no peace without truth and accountability. Their presence in one of the main squares in Turkey, Galatasaray Square, has transformed that place into a space of memory of justice. And the similarity of their resistance with the Argentina's Saturday mothers tell us a lot about the international aspect of our struggle. I think we should also look carefully at the political use of motherhood here, in my opinion, not to make any mistake when we are looking into such terms. States often explain motherhood through the reproduction of the nation, sacrifice and silence. But the peace mothers and the Saturday mothers, they reverse this image. They refuse to be mothers who raise soldiers for the state or mourn silently, but they become political subjects by themselves who demand truth from the state. This is also an important dimension of feminist peace, in my opinion. Care and mourning are not outside politics. They are central to the struggle of justice. Another brutal form of violence against women, especially in the Turkey's policy of war and occupation, is the transformation of the female body into a battlefield. Women's bodies are not only attacked during the wars, they are also used as a site of massacre, humiliation, and punishment. Rape, forced nudity, cutting hair, attacking funerals, mutilating bodies, or circulating images of bodies are not isolated individual crimes. They are performances of militarized masculinity and colonial domination and racialized violence. International law has historically failed women in situations of conflict. For a long time, sexual violence was treated not as an attack on women's bodily autonomy and political existence, but as an offense against honor, morality, the family, or the dignity of the community. It is, of course, important still that the international criminal law now recognizes rape, sexual slavery, forced pregnancy, and other forms of sexual violence as international crimes, but feminist justice cannot stop at naming these crimes. It must also ask questions about these crimes. Again, the similar questions. Why are some victims recognized while others are abandoned? Why are some occupations condemned while others are normalized? Why is accountability applied to some states while suspended for others? We had one case, again within the Turkey's borders, Ekin 1, a Kurdish woman guerrilla whose naked body was exposed after she was killed. And this was one of the most shocking examples in Turkey's recent history. Because again, here the target was not only Ekin 1 herself, but the target was Kurdish women's resistance. And the claim of women to become subjects in war, politics, self-defense, struggle for freedom. Her body was exposed and circulated as if it were a spoil of war. And the message to Kurdish society and especially to the Kurdish woman was this: we have power over your body, over your mourning, your dignity, and also your resistance. Very recently, we saw a similar message in the Syrian context as well, when a braid of hair allegedly belonging to a Kurdish woman fighter was displaced by a jihadist. And here it was again how the patriarchate itself was using woman body as a symbol of war. And you know, we were very much aware that a braid was not just a braid in that context, and it becomes a way of targeting the female body and Kurdish identity once again. And the response came from the Kurdish and Yazidi women, and afterwards a lot of other women coming from different nations and different identities, braiding their own hair in solidarity. I think it can be read as a way of turning the body back into a site of resistance against its use as a war trophy. So there is a continuity, sometimes open, sometimes more hidden, between patriarchal jihadist violence and the militarized masculinity of states. In one case, the female body is regulated in the name of religion, and in the other, in the name of the nation, security, or counterterrorism. But I believe in both cases, women's bodies are turned into a field of political domination, and this is one other issue that we have to focus on and fight together. So this is why I believe the Rojava example is so important. I do not think that we should read Rojava only as a part of the Syrian civil war or as a regional extension of Kurdish politics, but Rojava should also be seen as a specific experience in which the claim of women's freedom was viewed under conditions of war. Women's self-defense, the local democracy, co-chairship system, their assemblies and practices of social transformation in Rojava showed that another political imagination was possible in that region. I do not say that it was perfect. I do not say that it is completed, but we saw that there was an attempt to make this imagination real, and to fight for this was extremely meaningful. So I believe that we have no chance to consider Rojava fighters only the symbol of military resistance against ISIS, but also they defended women's freedom as a founding principle of peace and democratic life. Turkey's military operations against Rojava, its cross-border interventions, and its policies targeting Kurdish political gains cannot be separated from a feminist peace perspective. So I am still offering that they are all interconnected. Rojava has been targeted not only because of the regional power calculations. I believe that the main reason, one of the other reasons of these attacks were related to its representational meaning. So because it represents hope for the women all around the world. So I believe Palestine must be at the center of any discussion on women's struggle, feminist peace and justice. Recently, the violence experienced by Palestinian women emerged at the intersection of occupation, apartheid, displacement. I don't know, we can count on a lot of terms here: denial of healthcare, killing family members, and of course genocide, ongoing genocide. And Palestine shows us very clearly that women's rights cannot be reduced to an abstract question of equality under conditions of occupation and genocide. When a woman loses her home, child, school, land, I don't know, in Palestine context, her water, her freedom of movement, her right to life, we cannot approach, we cannot really only use the gender equality language here. And feminist justice in this context must be anti-colonial. It must be anti-imperialist, anti-Zionist, anti-occupation. Palestine also makes the question of class painfully visible. Blockade, occupation, bombardment are not only forms of military violence, they are also a regime that attacks the material conditions of life. So when we speak about the freedom of Palestinian women, we must also speak about the material conditions of their life. So this is why I bring Cyprus, Rojava, Palestine together, because all three places are the areas where Turkey is directly or indirectly connected to historical and current conflicts. As I mentioned, in Cyprus, this is the occupation and militarized division. In Rojava, there is an ongoing military threat against the political experience built by the Kurdish people and especially by Kurdish women. And in Palestine, there is the genocide going on, made possible by imperialist capitalism and international impunity. These examples also show that feminist peace cannot be selective. Here I want to be very careful. There are, of course, very important and powerful exceptions within the feminist movements in Europe and in Turkey. Many women organizations and comrades have taken courageous positions, but I believe that there is still a real problem we need to name here. In parts of Europe, European feminism, especially in places like Germany, Austria, and Switzerland, some women strongly support Rojava, for instance, but hesitate when it comes to Palestine. In Turkey, some parts of the feminist movement have kept a distance from Kurdish freedom demands, and Cyprus is often barely discussed at all. I think these silences show that feminist internationalism still has serious tests before it. Feminist peace cannot be shaped according to the foreign policy interests of states where there is an occupation, where there is militarism, colonialism, and war violence against women's bodies. We should be able to speak with the same principles, language of justice. I also want to turn back to Turkey again right now.
Sorry, we're going to have to end because
okay, perfect. Just coming to the end then. So,
sorry, we're going to have to end because
So then, I have three main suggestions, and I believe that this is important to focus on these aspects. First, I suggest that we define peace not as the absence of war, but as the building of justice. Second, the struggle against the transformation of women's bodies into battlefields cannot be narrowed down to the category of violence against women. And finally, feminist peace has to be intersectional. For this reason, I propose feminist peace not as a decorative language of inclusion, but as a transformative language of justice. And this is not a soft language of reconciliation without accountability. It is a radical language of justice against the ongoing genocide, occupation, patriarchal, colonialism, and capitalism itself. Thank you, and sorry for overcoming my time. Sorry.
Thank you so much, Ms. Oysal, for explaining the intersectional aspects of the struggles for feminist peace and justice through the lens of Turkish, Kurdish, and Palestinian women. Thank you to our esteemed faculty, our administrator and interpreters, as well as the People's Academy Task Force. Our next program will be Using International Law to Analyze Racism, Apartheid, Zionism, and Anti-Semitism. That program will take place on Tuesday, June 23rd. You will receive more information soon. Thank you again. See you soon. June 23rd. You will receive more information soon. Thank you again. See you soon.